Joyce, I'm going to start with you. Let's talk in detail, because I think this is really important for our viewers to understand. If this case gets remanded back to Judge Chutkan, which a lot of us believe is probably going to be the happy medium between the conservatives on SCOTUS and the liberals on SCOTUS, let's talk about what that remand analysis is going to look like. What would Judge Chutkan do to be able to determine what was an official act that has immunity and a private act that does not?
Right. So that's the ruling that's expected, that instead of saying Donald Trump has absolute immunity, his position, or very little immunity, the government's position, the expectation after argument is that the court will say some immunity for official actions, but maybe not a whole lot. Everyone seemed to agree in oral argument that private conduct by the former president doesn't merit immunity. The real argument is about these official acts and what their scope is. It's likely that means that the court will remand this case to Judge Chutkan, and they'll ask her to make that decision. And that's both a legal and a factual issue. Because there are facts, there is evidence involved, we could see her hold an evidentiary hearing. It delays the trial on the one hand, but on the other hand, that could be the opportunity for some of the government's evidence, the meticulous work that Jack Smith did in front of the grand jury. That could soon become something that Americans are conversant with. We have an opportunity to see more of the evidence against Donald Trump.
And Hugo, forgive me for a second, because I want to stay with Joyce on this. And please, chime in at any time, too, Hugo. I want to stay on this, Joyce, because we talk about remand, we talk about an evidentiary hearing, but I really want to dig down, because I also want to understand this a little bit more. You're going to have almost like a mini trial of a mini trial of a mini trial. If you're going to have witnesses come forward, number one, aren't you previewing for Donald Trump what the case is going to be if it goes to trial? Number two, we heard the verb expunge when we were hearing oral arguments in front of SCOTUS. The idea, according to John Sauer, the lawyer for Donald Trump, you would actually have to expunge, meaning you would take away the portions of the indictment that actually address the immunized conduct, and leave the illegal private conduct. So how would that look if I'm Judge Chutkan and you're coming to me as special counsel Jack Smith? Are you going to put a witness up who's going to testify under oath to me as the judge, and then I'm going to say, that doesn't sound like private conduct, that sounds like official conduct?
Yeah, so I think this isn't unfamiliar territory for prosecutors. Defendants sometimes ask to have part of the indictment stricken, removed. And so here, John Sauer, the president's lawyer, would be saying some portions of this indictment allege conduct that the Supreme Court has now said the former president is entitled to immunity for. And that all has to be redacted, stricken from this indictment before the case proceeds to trial. And that would put the onus on the government and on Trump's lawyers, really, to argue in front of the judge both the legal issue, where's the divide between what the Supreme Court says he gets immunity for and what they say he doesn't get immunity for, but also what's the evidence to back that up. And, Katie, you asked about whether that would let the former president's lawyers get a little preview of the government's case. It's something that you don't love as a prosecutor, but there's really no longer anything like trial by surprise, right, in the federal courts. They have all of this evidence in discovery.
Okay, but Hugo, let's talk about a burden shift here, because in a criminal case, the burden is always on the prosecution, beyond and to the exclusion of every reasonable doubt. But as we follow this line of reasoning, if you follow this idea that this is how it would go down in terms of a remand, shouldn't Donald Trump, though, still have the burden? Because he's the one claiming immunity. He's the one saying that I did this conduct, but I'm immune for it, versus special counsel having to show that it's actually the conduct that's not immunized.
Well, Trump's lawyers would say no way. And they've always maintained from the start that, this is an unjust and vindictive prosecution. And so I think that is an argument that the Trump lawyers have been pushing from the very start of this case. But I think what was actually really interesting on Joyce's point is, if this case, and this is slightly separate, but if this case doesn't go to trial because of the remand process before the election, because, you have to go back to the trial judge and we start striking parts of the indictment, and some of the evidence comes out, that might not necessarily be a bad thing, because if you think about the classified documents case, for instance, the seminal moment in that investigation was when the government put the photo of the boxes and all the classified documents strewn on the floor. And when everyone thinks about Trump hoarding classified documents, they look at the indictment and the boxes in the bathroom at Mar-a-Lago stacked really high up and in the ballroom.
Next to the toilet.
And if you're not going to get a trial before the election, then I think that actually, in its own way, gives voters a lot of information and a kind of image in their mind about what they think about the case when they go to the ballot box.
You're dialed in to Trump world very tightly. What was the reaction from them after the SCOTUS oral arguments?
It was mixed. I think the thing with the Trump lawyers is they will say publicly that they always wanted and they always believed that they would get absolute immunity because that was their position. But I think what the Trump lawyers did with respect to the Supreme Court and what they didn't do at the D.C. Circuit was to make this kind of bait and switch. And they presented what they wanted was absolute immunity and, this is what we're going to push for. And then they offered a compromise. And they said, actually, if you want an off-ramp, we'll give you the remand. And that was always in play. They didn't really use it at the D.C. Circuit. It was raised by one of the circuit judges at the D.C. Circuit. And then when they deployed it at the Supreme Court, I got a text from someone on the Trump campaign saying that was the switch, and you're seeing it now. And I think a lot of defense counsels around Trump's orbit saw that as a smart move.